Examiners and Optometry meeting on October 15th. Any modifications to the agenda today? I didn't have it on. And then moving along, do I have a motion to approve the meeting minutes from July 12th through 13th, 2024?
I'll motion that we approve the meeting minutes from July.
Any second? All in favor say aye.
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 Opposed, same sign. And so approval of the minutes from July 12th to 13th has passed. Do I have a motion for approval of minutes for the September 9th, 2024 meeting?
So move. Second.
All in favor say aye.
Aye.
Opposed, same sign. And motion passes. Let's move along right into the trade name approval. So are any of the following doctors with us today? No. And then, Gary, I assume you've dived into this one to approve? And then, do you have any concerns or updates for us? Okay. And this is a previous practice, is that correct? And just adding new doctors, or?
They're adding a new doctor and one's retiring, so it's a trade-out. Therese and Ackerman are the ones staying, and I can't remember who the one is leaving.
Joining. Gotcha. All right. Any concerns or any questions about the trade name for Ackerman Dries Trejo Optometrist? Do I have a motion?
Second.
All in favor say aye.
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 Opposed, same sign. And then motion passes. And then how about Dr. Barger? Is he here today? Okay. And Gary, Dr. Barger was with us at our last meeting.
Yes.
Do you have any new updates for us on this?
There is one question on this, which Tim had brought up about the corporate structure and doing business as versus about how that needed to be cleaned up. It had to do with their filing, I believe, with the Secretary of State.
Yeah, and I think it was, so this was the Vision Therapy Champions. Yeah, it was the previous name that they sought, which you all denied. You know, as long as they're not using, that's the name of their LLC. And as long as they're using the trade name as opposed to the legal entity name, with respect to the practice, there wouldn't be an issue.
There is an issue, or
There would not be.
there would not?
But that's the one thing to note here is that, you know, you previously denied the Vision Therapy Champions trade name that they requested. That is the name of their legal entity. And so the one thing to be aware of is, they would need to practice through, if you approve this trade name, they need to practice through that trade name and not the name of the legal entity, Vision Therapy Champions LLC.
Right, so do we really, as far as their filing with the Secretary of State's office, do we actually even have any influence with that to tell them they need to clean that up? Or are we compliant if we approve them to practice under this new trade name?
Yeah, I think the latter. As long as they're using an acceptable trade name, I don't think you can go back and take issue with the name of their legal entity.
Okay.
But if they start using the name of the legal entity, then there could be a problem there because you previously denied that trade name.
So then basically, I'm fine with approving this. I think that as we tell them that they have their approval, we need to indicate that they can only practice under this trade name.
Would you like to make a motion? Oh, go ahead.
Sorry, I have a question. Is this a situation where, like, I can't think of the word I want, but like pre-approval was given? Okay. Just double checking.
Pending, I mean, we had told them, even as we turned them down last time,
Okay.
if they came up with a name, that I could give them temporary blessing for it. which
And you did?
This is, yeah, but this
Okay.
has just recently
I
happened.
just wanted to double check because the website, it's already on there. And if that's done, then that's fine.
Okay. yeah.
Would you like to make a motion to accept
I'd like to
the
make a
name?
motion to accept the new trade name listed on our agenda for approval. And with that approval, we'll make them aware that they would operate only under this trade name and not the name of the corporate entity.
Does he need to say the name of the practice for the motion? No, okay.
I'll second.
All in favor, say aye.
Aye.
Opposed, same sign. And motion is passed for opticology vision therapy, and I believe Gary will be responsible for telling them, or Jan, what to expect with their LLC, so. Looks good. And Jan, what time will we expect Judge Snell? 9 o'clock, okay. I am going to go ahead and bump up to the report from the president because it's nice and short and sweet. The majority of what I'll be presenting will be later in the meeting. The one thing that I will be focusing on between now and July, we've had our first round of regulations pass, which means now our state law test is faulty. So the state law test will have to be rewritten just to reflect the new regulations. And I think it's long overdue anyway. So I have recruited Sheena to help me do that. And so we will be working on a test and then ideally submit something to you by early March so that you guys can review and double check. Maybe Jan's looking at me, she wants it before March. No. Any questions or concerns about that?
So between now and probably the end of the year, you've got a few more regulations that are going to lightly change
Yes, yes.
potentially.
So we'll have that in the back of our minds as well. There are a few questions on the test now that are redundant, I think, and then also a few questions that are very confusing how they're written. So I think between cleaning those up and adding some just very fine details for our new regulations, I think we can address that. So. And Jan, do you want to move on to your report?
Okay, sure. The enterprise licensing program, I went to it was a reception for the updated website. The OITS had a little reception, and so I was talking to them about the new ELP platform, and they kind of told me that they did not think we would be live by March of 2025. So I don't know where exactly we stand, other than they did tell me that they were going to be sending our data to Acela to start the ball rolling on their end. So we'll see. It's also a good time. Hang on, I have notes. They had some questions on like the application photos. We usually had them tack that onto the reference sheet. Can they just upload one photo to the thing, and then if we still need them to do the references, to have them be able to cut and paste it onto that reference sheet, and we would be good to go? That makes sense?
Yes, I wonder if they even have the capability. For example, now when I write a referral for a student applying for optometry school, I log into a website, write my referral on their website. And so I wonder if that would be easier for practitioners just to say,
It probably would be. It'd be less, less paperwork on their end, something else to get lost in the mail and something else, if we're trying to cut paper.
sure.
And I can see with, if Excella can do something like that, that we could have a special login for the references to log in to do the reference.
Yeah, or to send the information, that would be ideal.
Okay.
Well, that's a little disappointing.
Yeah, and the other thing they brought up is that Acela can have the law exam online if you wanted it, but then it would have to be open book. And I know some agencies that have the law exam online, open book, you have to get 100% to pass because it's open book. If you get less than that, then you have to redo.
Meaning they would do it online in their own home or?
Exactly,
Gotcha.
exactly. You know, and be able to look it up, and so there's no reason why they couldn't get 100%.
Okay.
But something to keep in the back of your mind. They also said that it would have to be manually graded. They couldn't grade it, but they could do it online. And then on the reciprocity, the license verifications from other states that we have the applicant fill out, send to the other state. A lot of states are going to electronic verifications, and Kansas will be going to that, I think, in January of 2025, that you log on and you can actually see real time for the verification. And so I was wondering if we still needed them to do that, or if it was just easier for me to go to the state's website, verify their license, and then instead of having the applicant do it. Because a lot of states will not do a paper verification.
I guess I don't understand your question.
We have, in our reciprocity application, there is a form for the applicant to fill out to send to the state that they're coming from.
Okay.
So what I'm proposing is to get rid of that. They write down all the states. I go to each state individually, verify their license that way. And if I need to, I can call the state to verify it. Instead of, again, less paper. You know, the ones that I have been getting that been filling it out, they're sending it to me, they're emailing it to me anyway, so.
I think that sounds reasonable. I know at some point we made a motion to accept new application forms. So does that officially have to go through a motion once Jan's ready to change
Yeah,
that?
and now with Acela, it's a good time to maybe look at our applications and update them. I know one thing that they brought up at Arbo was to put all the stuff that is not subject to open records in one spot, so then you could just blank out that whole spot instead of having it throughout the application. So that might be something else we look at doing. But now's a good time to be working on it.
Yep. Is that something, Tim, that we need to make a motion on, or
And I can,
no?
Not at this time, but when
I
you.
can work
you're
on
ready to address.
the application and send you a proposed one. Because I know I need to update the reciprocity with the military spouse,
Gotcha, okay.
you know, because we have that whole thing. And then, again, one last thing that came up this last week, actually two other things. On the COPE categories, Kansas has 3. They have general farm and practice management. So when COPE comes over into our database, there's a program that takes the COPE category and classifies it as one of those 3. So what I'm wondering is, again, with Acela, and it's a new thing about just having the COPE categories come over as they are. I think the statute and maybe the reg says you have to have like 5 hours of therapeutic. Maybe define therapeutic as anterior segment, posterior, so then they know, because a lot of them see pharmacology and they think that it actually has to be pharmacology courses that they have to have. Okay. So instead of having the crosswalk, we could just have them come straight across, and as long as they have CE in those categories, and we can define those for them coming out of COPE, and that way it'd be less confusing.
Are we having issues with the, Kansas has defined their synchronous versus non-synchronous versus virtual synchronous differently than Arbo? Has that been an issue at all with our
No,
system?
because I have them in the back end of the program. I have it tell them that if it's a synchronous, then it's live or whatever. Synchronous in person, synchronous. I have it in the back of the program, or in the back of the program. It's doing its little thing. It's coming across as live. Okay. Just for that, because I think Arbo still has some that are classified as live instead of that. And then the certificate, and I put some online for you to look at and review has to doing electronic certificates. It's one of the things that Acela will do. Once a person renews their license, it'll be, unless there's something that I need to do on my end, they'll automatically get the certificate. And so I put some examples of some that are online for you to look at to see which ones that you liked.
Okay.
I think they can also, excuse me, take the embossed seal that we have and maybe put it as a watermark on there. But that was,
It's reasonable.
so can I just pick one, or is there a preference that you guys, and I think I could probably, do I have time? Well, I'll show them up on the screen if you wanted to look at them up on the screen.
We can do that real quick. Yep.
I can do that, right? If I plug in up there.
Do you have a comment on the, her first, either the license, I feel like part A or B, you had a comment. And so I just want to mention that at the ARBO meeting in June, discussing some of the options, NBEO would be willing to offer our state licensing test. They would offer at no charge their psychometricians to look at the questions and verify that we are legally doing everything correctly, and also administer the test, likely at no additional charge. So that's something that we can look into as an option as well. That was kind of a brief discussion there, but they really do have a lot of very good options for us to take advantage of long term. So just they're pretty strict on some of the requirements. So do you have to be in a certain location to take the test? Will they end up charging us long term? Will they charge the students? So there's a whole lot of caveats we'd have to work out, but we are getting to a phase where big picture nationally, a lot of students are suing testing entities for not passing and questioning the reliability of their questions and so on and so forth. So it gives us a lot of good backing.
There's a portion of our test that we're still statutory obligated to give, correct?
Yes, and I think we'd also have to just determine, we would still be requiring the test. Do we also have to administer it? I don't know. Those are some things we'd have to kind of work out.
Sorry. And then to get to the other ones. And go to. That button. This is just another one that they gave me.
So Jan, you think this would also replace the hard copy form that you mail out that we all individually sign?
No, this is just for the renewal.
Gotcha.
You know, that will have the expiration date. We've kind of went back and forth on that, and I'm thinking, and I keep saying that no, and I've showed them a picture of the actual signed license. It's like, no, I think the board still wants to give these out. Senate Bill 66 is we have to be able to let them print something out that shows that they are licensed.
Okay.
And most of the places want the thing that has their license and the expiration date.
So you're sending something out digitally now,
Right.
and you're just creating those versus this would create it for you?
Yeah, it would automatically create it for me.
I would say I trust you to choose one. I really like what you send out now. I think it looks professional and what you're doing, but I am okay defaulting to Jan on
Kind of
the
replaced the little
font.
white cards because everybody was wanting, especially the ones that didn't renew until like May 31st, they were wanting something electronically, and so that's when I started sending them electronically for that reason. And so then if somebody still wants a little card, I'll do one, but,
Okay.
okay. I'll play with them and I'll come up with something and I'll get with Gary and we'll figure it out and make sure that it looks hunky-dory.
Because we're still talking about putting a watermark or something on it.
Yeah, we're still talking, yeah. The state seal or something. You want to see the third one or?
Sure.
Screwed it up.
Kind of looks a little more like our DEA card.
And this is another wallet card that they gave me an example of. And I kind of like this one because it just is a reminder that any change to the address or name, that they have to notify us, it's right there.
And it's got a watermark on it already.
Yep,
I like this one as well.
okay. I'll go with it, I'll start playing with it and get something set up that looks halfway decent then. And that's all I have,
Thank you. That wraps up Jan's report.
part of it.
I am going to move on. Judge Snell has arrived, and so we will be moving forward with case number 2020-02 for Dr. Wade Abbey.
I didn't email him a copy. Sorry. I sent it to the board members, I just forgot Judge Snell.
Jan, while Judge Snell is reviewing his information, is it appropriate that board members should be returning notebooks to you regarding the case to be shredded? Yeah, okay. So Jan gave everyone 3 notebooks at our previous meeting, so eventually bring those back in and she can take care of those.
A burn party.
And so, I mean, procedurally, I don't know how you want to proceed, but I can certainly make some comments about the draft. The board members now have a copy of the stipulation, proposed stipulation, final agency order, and then they would need to take action on motion to approve, formally accept this. This is a proposal from Dr. Bircher, acted as the investigative member here. It's a proposal from us that we've agreed to with Dr. Abbey and his counsel, and so it's to the board as to whether or not they want to the remaining 4 members if they want to accept the proposed stipulation here.
Well, we'll go ahead and I'll be a little bit more formal at first. And so what I'll do, since still serving as the hearing officer in this matter, I'll go ahead and call the case, which is 21B00001 BOPT, which is the OAH number, Office of Administrative Hearing Numbers. I think the board's number is 2020-02. And yes, as you heard, counsel mention, this matter has come back to the board. And I think I came over and I visited with the board about this back when it first had gotten remanded, and then we were on hold for a little bit to see what was going to happen, if it was going to get taken up further, and it didn't. So now it's back before you on the remand order from the Court of Appeals. And so we originally were going to go to hearing today on the issue, not on the issue of the facts, because the facts had already been decided and determined, but on the issue as to whether or not there should be any sort of penalty imposed on Dr. Abbey based upon the conduct that had been found and then approved throughout the appellate process as the matter went up, because there were certain aspects that did get reversed, but there were certain aspects that got affirmed as well. And so in lieu of that, counsel has been working diligently behind the scenes to attempt to get this matter resolved. And my understanding, based upon email and then having just reviewed it, is that there has been a consent agreement that's been entered into between counsel and Mr. Abbey. Dr. Abbey, is it Dr. Abbey? Dr. Abbey, I apologize. No disrespect intended, I apologize. For what it's worth, I do that to a lot of the boards as well. I'll address them as Mr. Miss and then find out that I shouldn't be. Anyway, so there's been a consent agreement that has been reached with regards to how the attorneys and Dr. Abbey feel this matter should be resolved. Of course, that is all subject to your approval. You get the final say as to whether or not you agree with that consent agreement. In other words, they've come together, but you have the final, you get to make that final determination as to whether or not it is going to get approved that way. And so you have been presented with a copy of that consent agreement. And I mean, subject to allow counsel to make their comments, I think that would be appropriate if counsel, I know that Tim has already made a comment, but Ms. Boquist has a comment as well. Or if you want to make formal comments, we can allow that if you feel that it's necessary. Otherwise, then it'd just be up to the board, and I assume that you'll have to determine, and this is going to fall on the vice chair because the chair is conflicted out of it, to decide whether or not you want to go into a closed discussion like you would if this had gone to a hearing. The deliberative process is usually done in a closed discussion. You can do that, or if you're comfortable with, if somebody's comfortable with just making the motion and getting that process started, you can certainly do that in the open meeting as well. And so that's kind of where we're at. So I guess I'll leave it up to, do either of you have comments that you want to address to the board in advance of them making their final decision on that?
Yeah, I'd like to make a quick comment if that's okay. So the stipulation you all have in front of you, it was negotiated between Dr. Bircher as the investigative member, myself, and Dr. Abbey and his counsel. You know, we outlined sort of the procedural history of the case, you know, the initial hearing, the final order that the board entered, the appeal to the district court, the appeal to the Court of Appeals, and the Court of Appeals decision. And then, as Dr. Snell alluded to, ultimately it was the Supreme Court was requested review. They denied review. It came back to now the board to determine what discipline to be imposed. We're proposing, you know, certain sanctions as we've outlined here. It starts at paragraph 12 of the stipulation. That's page 3. And so we proposed a 3-month suspension. And you know, historically, after the board's final order was entered, up until the point where the district court, the appeal was taken to the district court, and the district court ultimately granted a stay of enforcement of the board's final order. There was a period of 2 months and 13 days that Dr. Abbey was actually suspended until the district court stayed the effectiveness of the final order. And so the 3-month suspension provides him credit for that time period, and then contemplates that he would serve an additional 17 days to complete the 3-month suspension. And so we've outlined that that would be starting tomorrow, October 16th, through November 1st would be that time period. You know, the suspension is intended to automatically terminate. So, you know, Section B then talks about a return to practice, and that he returns to practice and he's going to comply with the optometry law in doing so. There's a delegation of authority to Dr. Bircher as the board president to review you know, sort of the incidents of the practice setting, for her to make a determination as to whether or not she believes it complies with the optometry law. If she doesn't, then you know, she would need to petition the board to render some kind of a decision on you know, the future practice setting. We also provide Dr. Abbey with the same opportunity to petition the board for the determination whether or not the practice setting complies with the law. So that's something that we'll work through. You know, we're intending to work through, you know, in the interim, the 17-day period, so that on November 2nd, you know, he's up and running as far as his practice setting goes. And then finally, we contemplate an administrative fine of $2,000, which I believe that's consistent with what the final order provided for. So it's been negotiated, and I would request approval of the proposed stipulation and final agency order.
We certainly appreciate the opportunity to be here and your time today. I would just echo the request that the board approve the negotiated stipulation and agency order. I would be remiss if I didn't mention the good work of Mr. Reisner, my opposing counsel, and of course Dr. Bircher, who have both put significant time into getting to this point of the negotiation. And so we hope that you will find it a fair and reasonable approach, as we all have. If you have any questions, I could certainly stand for those, but otherwise, I just request that you approve it. Thank you.
Any of the board members have any questions for either council at this point? Just making sure, just in case. So then with that, Madam Vice Chair, I would turn it over to you, and we just have to decide whether to go into a, like I say, there is provision allows for a closed session if you feel we need to do so, but if somebody's comfortable, you know, then we don't have to do that either. Either way you do it, you have to at least come back out into open meeting to make your final decision, just so you know.
I think I would like to motion for a brief closed session. Can I make a motion or request a motion? Sorry.
No, I mean, I don't know that you can necessarily make it. I think it actually
Okay.
would have to be made by one of the other
Entertain
members.
a motion.
Madam Vice Chair, I'd like to request that we go into executive session for a period of 20 minutes for deliberation.
I'll second.
Okay, so we will go into closed session and return at 9:31.
Chairman. I do have a few questions, specifically about the section on returning to practice. Sorry. Okay. And, okay, so it says that eligible to return to practice after November 2nd. Basically, I just want to know a little more specifics on what's required or allowed for this. Like, when we establish back to practice, it sounds like we have the ability to review and make sure that the practice is following optometry law. If the practice changes, do we then have the ability to do that? What is our ability and timeline here to keep an eye on this compliance?
Yeah, so as far as the board's process goes, anyone who's establishing a professional entity needs to request a certificate of good standing, which would be attached to the articles of formation incorporation that are then filed with the Secretary of State. And so that's one piece. And Dr. Abbey has requested the certificate of good standing. He's provided a copy of, is it an LLC? OPA, okay. So provided a copy of the Articles of Incorporation, which establish that the professional purpose will be the practice of optometry. And he is the shareholder of the entity. They provided a copy of the corporate bylaws, which will be reviewed as well. If you recall some of the facts involved in this case, there was a management agreement, so we'll request any management agreement that may be in place between the PA and the Administrative Services Organization. If that's in place, we'll look at the physical practice setting as well. And I don't know if you want to speak to any of this, Diane, but we'll review that as well. Sort of the entire, I guess, outline of the issues that we had in the previous action. So we'll look at the relationship with the Administrative Services Organization, relationship with employees, relationship with the optical. I mean, that'll be all part of this review. Did I address your question, or is there another part of it?
So is this a one-time review? So if there's a change in employment or structure, is there any requirement to report that, or how often do we have the ability to review that?
Yeah, so this contemplates, at least an initial review up until the point where Dr. Abbey returns to practice. After that point in time, the board would always have the ability to investigate, but there's no, compulsory, reporting, no compulsory audit, nothing along those lines that, the board would. We're not putting any of that into this stipulation. It doesn't mean that the board could not do that, but we're not building any sort of a mandatory review into this, other than, contemplating the initial review.
Okay. Are there any other questions right now from other board members along those lines, or on other details in the agreement?
So you said you'd be reviewing the agreements between his PA and any other entity. Does this, if those agreements change after that initial review, does that obligate them to notify us of that change?
No, there would be no obligation to notify of any change. I suppose, what you're getting at, that it wouldn't be anybody's best interest to represent something and then immediately change it after the fact. That could definitely open up anyone to,
While it's not in anybody's best interest, there is a history. So that's a concern.
Well, yeah, what we want to do is ensure that if Dr. Abbey returns to practice, we want to make sure that the structure presented complies with the law. After that, if there is an issue, it'll be addressed the way that it should be addressed. But otherwise, what we're focusing on is completing the suspension and the return to practice and making sure that what is set up complies with the law.
I want to say one quick thing, and then yes. I want to be clear with my line of questioning, I'm not intending to, I don't want this to be construed as a feeling of, I don't want to feel like I'm harassing a doctor who is in practice. I just want to make sure that I understand the plan moving forward. And then, yeah, go ahead.
Madam Chair and board members. So I think we all have a shared interest in making sure that there is 100% compliance moving forward. And so I wanted to convey that sentiment. Previously, there's been a lot of litigation battle over what the legal landscape was, and now we have that clarity moving forward, which is very helpful, because that will allow Mr. Reisner, Dr. Bircher, and us to have a meeting of the minds on what that landscape is, at least, and then we can make sure that we are hitting that target. It is Dr. Abbey's interest and desire, of course, to be compliant, not only for this initial review, but on an ongoing basis. Thank you for the opportunity.
Can I make one additional comment? Something to consider here, too, is, the final order found certain violations that went beyond the, corporate structure issue. What's now been returned to the board leaves that one remaining violation, and that is, practicing through an entity that's not authorized to practice optometry. And that's a pretty easy issue to address. We look at the structure, and we do want to look at the relationship with any management organization, but that's the sole remaining violation. So to the extent that there's any thought given to the additional violations, which were ultimately reversed, that's something I think you need to take into account here.
I think, again, on my level, I'm generally comfortable with the stipulation. I am wondering if we can, if other board members are interested also in adding something as far as future review. And I understand what you're saying as far as the other violations that were, the findings were reversed. And I think when Dr. Beaver was discussing history, we're talking about previous issues. And just to avoid potentially preemptively this happening again, any confusion about the optometry law. Is there something, or is there any interest in adding something specific as to annual review or every 2 years, or a request that if changes are made, they are submitted for review? I think my goal is to make sure this doesn't continue to happen, that there isn't any confusion that leads to cases and complications, if that makes sense.
I may defer to Ms. Belquist as far as that question. I think, if the board wants to propose some kind of change, certainly can.
I would need a moment to speak with my client, first and foremost, for any changes before I could commit to any agreement on that. The thing that I am processing in my mind, and the question, though, is, we have the plan for him to practice under his corporate entity once it's approved and fully set up. but I also don't know if that's going to be a 5-year plan, 10-year plan. I don't know how long. And so with a monitoring requirement that would go out any lengthy period of time, I wonder how that may hamstring him from pivoting if he would ever want to pivot in the future. So that would be a concern that I have without having spoken with my client as far as a final definitive answer.
I absolutely understand. And again, it's not my desire to cause that kind of situation. And we do, in general, you know, for applications and things like that, you know, we try to meet regularly, even if via Zoom in between our in-person meetings, in order to help facilitate those decisions so that doctors who are waiting on other decisions in order to practice, we try our best really in between. So it wouldn't be like something where you have to wait till our next quarterly meeting. We try to keep these timely, just to add to that conversation.
I think the ultimate question, though, and listening, and it's just me being the hearing officer, listening in between everything. So as I understand it, the concern is in this, and correct me if I'm wrong, and I'm trying not to invade the privacy of the deliberative process that was going on, but the concern is, say after 6 months, it turns out that this corporate structure doesn't work, and Dr. Abbey decides that he wants to partner with somebody again, and he partners with somebody similar to Physicians Eye Group, and it becomes the exact same scenario all over again. That's the concern. That he made it through the approval process, he's gotten back into practice, he's gotten his license back, and then 6 months down the road decides this isn't going to work. And so I'm going to affiliate myself with somebody, and what kind of review does the board have in order to ensure that something like that doesn't occur? I understand it probably wouldn't be in Dr. Abbey's best interest in light of the history that he has, and I'm sure he understands that as well, but that is a concern that I'm hearing based upon what's being said here. Now, the opposite, the counter to that is understanding Dr. Abbey's position, and that is there shouldn't be a process that should go on for years. You know, and so, you know, you don't want a situation where Dr. Abbey's having to look over, you know, if he's, not to downplay, but if he's being a good boy and he's playing by the rules and he's not throwing sand out of the sandbox, then he shouldn't have to report back, you know, for the next 5 years. Is it reasonable for him to have to be subject to this same return to practice provision that's here just because he makes a change or 2 or 3 in the next 5-year period? And so, as I understand it, that's kind of the issue that we have here is, how does the board get to the point where they have reassurance that this isn't going to be something that within the next 6 months or 2 weeks that, you know, it doesn't become a recurring issue, but at the same time, Dr. Abbey going, I don't want to have to look over my shoulder for the next 5 years. And so that's where I see it, just as the hearing officer, you know, listening and paying attention. I don't know how you get to that particular point, but I hear it didn't seem like we're all addressing the same issue, so I'm trying to point us in the right direction, so that there can be a determination made with regards to that. And I don't know if that's something that Dr. Abbey's willing to, you know, deal with. Obviously, I don't think the board intended for it to be a long, drawn-out process by any stretch of imagination, but I think it's more so just to make sure that there's more than just a November the 2nd, the president comes, the chair, president, whatever the official title is, I apologize, comes in, takes a look, makes a determination that everything seems to fit, and then November the 5th, there's a change in structure, and the board has no way of being able to come back and look at that and make sure that this new situation complies with what was intended by this consent agreement, if that makes sense. So, yeah, I probably have said way more than what I needed to at this point, but I'm just trying to further the discussion and see if we can can get somewhere.
Back onto that. A couple of points I just want to leave in your minds. The Court of Appeals definitively held that Dr. Abbey did not knowingly violate the statute that they determined he violated by the corporate structure. So he did not do this intentionally or willfully. And twofold, he is subject to your jurisdiction as an optometrist at any point in time. And so you continue to have the regulatory jurisdiction and oversight consistently. Third, I don't know yet because I haven't seen agreements, but I would contemplate that there's likely to be some sentiment of a term or an anticipated term to the agreements when he gets his corporate practice set up and the arrangements solidified. He is not going to be going through the work of establishing his own private company, getting these agreements and operations off the ground, only to pivot in a very short order. So that's certainly not the intent by any means. I'll leave you with those thoughts.
I might request that we convene another executive session. All this information just came to us this morning during our meeting, so we do have a lot to discuss and work through. Would everyone be open to another executive session?
Just in case, because I know that Mr. Resner, it seemed as if he was pushing his microphone to possibly address the issues that were raised by Ms. Belquist, so I want to give him that opportunity before you make that determination.
Yeah, I was just going to add, 'cause I follow where you all are going, I believe. But there are two things, I guess, that the law requires that, I think you should be aware of. That, obviously, if an optometrist is going to engage in the practice, they need to notify you in advance of the location. So if the location would advance, there's a statutory obligation to notify. Similarly, if there would be a change in corporate structure, there would have to be an amendment to the Articles of Incorporation. The professional corporations law would require that the board would issue a certificate for any amendment to the Articles of Incorporation. And so those are two pieces of oversight I think that the board has here, just so that you're aware of that.
So, Tim, are you sort of implying that if we were to pursue some additional language in the agreement, that might be redundant with the existing law?
Yeah, I think that's something to take into consideration. I mean, if you're going down this path of making sure there's some kind of review, those are at least two things that are already in place.
Tim, one last question. Does that same statute allow the board to request contractual papers associated with the practice?
It would be limited. You're talking about the change in the corporate structure?
Yes.
It would be limited to the Articles of Incorporation.
Okay.
Do I have a motion either to go into closed session or to take action on this?
I'd move that we go into closed session again for a brief, maybe a 10-minute session.
I'd second that.
All in favor? All right, we will go to closed session and return in 10 minutes at 10:06. All right. Call the meeting back to order at 10:07. At this time, does anyone else have any comments? Okay. Does anyone like to make a motion to take action on this stipulation?
I'll motion we accept the, what we're calling it, the consent, there you go. What he said.
I'll second.
All in favor?
Aye.
Oh. Oh, after calling for the motion? Oh, appreciated. Thank you. Okay. Any discussion? All right. Thank you. All in favor?
Aye.
Aye. All opposed?
Aye.
And stipulation and final agency order is passed, accepted.
Request, like I said before, is if somebody can just get me a copy of the signed version for our file at our office, and then that way we'll get everything closed out and we'll be done on our end, and we'll wait for the next time. Not Dr. Abby. We'll wait for the next time.
I'll be sure and get it mailed over to you. Do you want me to put it in the file online, the online?
That's fine. If you want to do that, you can just upload it to the e-file system and just let me know when it's there, and then that'll be sufficient. I'll print it off and we'll get the hard copy file returned and be done.
Thank you.
And you don't need me for anything else today, right? All right.
Thank you.
Thank you for joining us.
Absolutely. Thank you.
Appreciate it.
And we are going to take a 10-minute break and resume at 10:20.
You've had a break this whole time.
Good morning. We are going to return to the reciprocity with Dr. Choate. He is
Choate.
online, so you can tell us how to say your name as well, please.
Choate. Good morning.
Morning. Officially, an investigation was not opened on this, but I am choosing to recuse myself from the voting process on this reciprocity.
Dr. Cho was represented by counsel. I think she intended to be here, but I'm not sure.
You want me to check on her?
Yeah, I mean, it's Diane Belquist.
Want me to go get?
Yeah, that'd be great. I think we'll wait. Dr. Choate, we're just looking for your legal counsel. She stepped out, so.
Okay, thank you.
You're doing awesome. You're gonna make a coup and a play for chair.
30 minutes early.
Do you think we wait until 11?
Yeah, I mean, especially if Diane's not here, we probably should.
So Dr. Choate, we're a little ahead of schedule, so we will wait for your representative. So I think we will move forward with the meeting and then come back to you at 11 o'clock.
Okay, thank you.
This is good news. We're ahead of schedule because that means we're moving right along. Let's move forward to the report of the Vice President.
All right, let me get all my stuff pulled up. Okay, so in September, I had the opportunity to visit the National Board of Examiners testing location in Charlotte. And did anyone, just out of curiosity, get a chance to watch the Arbo happy hour on that where they gave the presentation? Okay, cool. So just for a little bit of background, so they have reworked Part 3 completely. And a little history. So Part 3 first started in '93 and used to consist of 4 skills labs or skills sections. And then starting in August of this year, they have implemented the new Part 3. And as a board who is then seeing applications of licensees who've taken these boards, we wanted to be well informed on what the new testing entailed. So I will say it is quite impressive. They have put a lot of work into it. They started developing it in 2018 and are just now implementing it. And a lot of the reason they wanted to move to this is optometry has evolved quite a bit over the last few decades, and they wanted to make sure they were keeping up with it. And they wanted to make sure that the testing was more standardized and also more clinical in nature. So the way it works now is there are 12 rounds. 10 rounds are patients and encounters with patients, and 2 rounds are skill tests. So the 10 rounds with the patients, and they have a very nice setup there. They have exam rooms, and they have patients who are hired and trained on how to answer appropriately. And they get a little bit of a background, but then they are taking a history. They are making notes. So they have their testing program is set up very similarly to an EMR. It's actually a very nice looking EMR. And they fill it in, chief complaint, history, and then they get to choose special testing they want to do. And they request the special testing. They have to justify the special testing, so they can't just order something. They have to say why they're ordering it. Once they lock that in, they then get results that they need, whether or not they picked the right testing. So then they still have a chance to make sense of the rest of the case. They come up with an assessment, they come up with a plan, they educate the patient, and they are graded on all of that. The way they came up with the criteria was based on a lot of research and survey as to, what are optometrists seeing and what are things that are critical to patient health to make sure that those things are being evaluated. And so actually on their website, they have a really nice outline of like the different clinical assessment, management skills, patient education, professionalism, and how they're weighted. And then they also have, anterior seg disease, posterior seg disease, glaucoma, systemic disease, refraction, neuro, contact lens, binocular vision, pediatrics, and again, weighted in levels of, how much of this are you seeing in the population, and also how critical is it to patient health. The questions they come up with, they have a huge pool of subject matter experts, which are basically optometrists. They try to choose a lot from academic settings as far as people who are working with students. They try to also have a variety of backgrounds. And then these questions get submitted, and then they get ran through multiple times by multiple groups to make sure that they're making sense, that they're testing. They have, I think we talked about it a little bit last meeting, they've employed a psychometrician, who's literally their whole job is the psychology and accuracy of testing. And there's actually groups out there that are psychometric groups to make sure we're following standards, and so they have all of that. And then the last thing, something we ran into 2 years ago was that there was a particularly low pass rate one year. And there was a lot of complaints from applicants here, that they needed to retake the test and it was unfair and et cetera. They have a system now where every person is automatically graded by 2 people. If the second person doesn't agree with the first person, it automatically gets kicked to a third person. And if that person is also not within a certain statistical range, it gets reviewed by a director. So they have a lot of redundancies built in.
Can you tell us, excuse me, are the graders employees? Are they optometrists? Are they?
The graders are employees who have been trained specifically to evaluate. And I'm trying to think if they're also optometrists. I genuinely don't know that for sure. I want to say they are, but I couldn't find that out. The rooms are set up too so that there's 2 cameras in every room. So all of these are being recorded so that they can review. Also, all of like the slit lamp and BIO, all of that's recorded so they can review all of that as well. And a lot of my interest in going was also to see if this is something that would help us reduce what we are doing at our application by exam, if they're providing a really well-researched, well-founded test. Genuinely, no. It was when they first presented it, they were like, someone was like, this is like the best test. And I'm like, all right, we'll see. Like I was pretty, it's really, they have a lot of, like I said, redundancies and a lot of statistical analysis and a lot of work to make sure what they're doing is reliable and clinically relevant. And their first round of scores will come out in December. So August to December, there haven't been any scores released because they're standardizing. And then then in December, after that, they'll have monthly score releases. So we'll see a little bit how it goes from there. But honestly, I think it's pretty excellent. It's pretty impressive to see it in action. We actually had the opportunity. They have two-way mirrors, and you can go see what they're doing. It's a good setup. So.
I will just say, at the national meeting, Sheena really put them on the spot in front of everyone, and now has a face and a name at the ARBA meeting. And so we really sent a critical eye into the board testing to give us an idea of what's happening. So, can you give us a comment on timeline? So we had a lot of applicants complaining that they took the test. It surprised them that they failed. They didn't know why they failed, but that we were not going to get scores in time for them to take or apply for a Kansas license. So can you just talk about how many students can they do at a time and timelines?
Out of curiosity, so no one this round yet, right? Because they haven't, or is it people who failed in the spring who are going to be retaking the new part now, or just in general?
Just in general. Go ahead, Jen.
We have one that took it in August that she could not take our exam because she didn't pass part 3, so she was taking it August 1st.
Oh, okay.
So we'll have one. Hopefully I'll get scores
In December.
in December.
Okay. Their facility can test 12 people at a time and on a day. So Monday through Saturday, they have 12 students, but one of those days they'll double up and do actually 24 students. And I can actually look into that compared to before and see, I can ask them what their spots have been like if they've been filling up or not. Again, a couple years ago, we had someone who said they didn't have the opportunity to take the test because all the spots were taken. But then it turned out later there were other things in their own personal schedule. They were not willing to reschedule. And they have the opportunity to start taking it beginning of 4th year.
So I think we're seeing more and more applications come in where the students are taking part 3 before they've passed part 2. And I guess we need to keep that in mind, that they may not have their full clinical skill set out in the real world. And I just think there's a lot of nervous students about the change and what does the change mean and how do we move forward. I don't know if they collect data or if they report data on colleges. I'm pretty sure they do.
Mm-hmm. On pass rates?
Mm-hmm.
Yeah, they do.
Okay.
Yeah.
Okay. And so that might...
Just 2 years ago when they were at that low rate, we'd had those numbers. Because I remember Oklahoma struggled, which was atypical for them.
So currently our bylaws say that we do have to administer a test for applicants. And starting with Dr. Sparks, we've really been leaning towards when can we approve this Part 3 PEPS exam versus a in-house clinic, and then the test we'd be administering would be the state law test. So keep that in mind for the future.
If that change were made, would it allow new licensees to be granted a license throughout the year, or does our statute stipulate that we can only issue new licenses once a year?
It simply just says you shall examine at least once a year. You could do it more frequently, but you're required to at least once a year.
So the progression process would potentially be the interview, the law exam, and all their submitted paperwork.
Any other questions about the PEPS exam?
One comment.
Sure.
If we did do away with the clinical, what's to say that we can't, or the person, my replacement, can't do a law exam, have them sign up 30 days in advance, once a month? So that way they'd be licensed regardless of whenever, pending board approval. And we could have it here in Topeka somewhere, probably here at the State House somewhere, in a room on like a Saturday morning or something.
Okay.
Just a thought I'd throw out there.
Sure. Just one other final question. I know it's early in the game, but are they anticipating a timeline of when scores will be released? And will that timeline shorten as we get better at taking this test and moving forward?
So their plan is the first round in December and then monthly after that.
So in December, we should get August.
Correct.
Gotcha.
August through December.
Any other questions about the PEPS exam? All right. I'll let you continue, Gina.
We need to set the date for our next annual exam. So, Jan, is this something that you looked at all as far as, concerts happening?
Last year, it was supposed to be in Topeka, and it was going to fall on that same weekend. And then they moved it out of Topeka and on the different weekend, so we would have been good. So no, I'm not even looking at that stuff.
I will just throw out there any conflicts with July 18th and 19th.
Not on my part.
Works for me.
Any concerns that's too far out in July?
At one point in time, they did move it to June.
If it saves your marriage, we can bump it a weekend.
Yeah, they moved it, yeah, because the thinking behind it when they moved it to June for, I don't know, 2 or 3 years was that everybody graduates in May, they had to take the exam in June, and then they can start practicing a whole month earlier than making them wait until July.
I mean, we could maybe do earlier in July, but with June, I don't know, AOA and ARBO are in June. So.
And I have some conflicts in June as well, first part of June.
And I'm really nervous about this PEPS exam and giving enough time for tests to get in. So even that 30 days is a big window.
So I'm 18th, is that where we're at? Are we moving it up?
Move it up to the 11th? I don't know.
Yeah, I could do the 11th too.
Yeah.
All right, let's do the 11th.
July 11th and 12th.
And then plan on the 11th and the 12th on your calendars.
Mm-hmm.
Were you on the board last year when we did this part? I can't remember. Okay. So everyone's been through it now.
Any information from Madam Vice President?
No, that is the end of my report.
All right. Any report from Dr. Beaver?
I do not have a report, but I have something I'd like us to briefly discuss. So everyone is having to do the one-time renewal course, the 8-hour course for their, not DOE, not,
DEA?
DEA. So is there some thought as to whether we allow credit for that towards our hourly count?
I have been allowing that.
How do we verify that?
They submit their certificates to ARBO. ARBO verifies it from their certificates that they took it.
Okay.
Are they getting a full 8 hours, or what are they getting from that?
That I don't know.
Because I don't know that it's worth 8 hours. That's why I'm wanting to have this discussion.
Sure.
Just assumed it was a full 8 hours.
Can you,
And it's not live.
right.
Is it COPE approved technically? No, okay. So would it be something like we would need to submit for review, like we would other CE classes and decide?
Well, it's a national course. It is blessed by plenty of entities. COPE is just not one of the listed entities. So that's kind of why I'm asking the thoughts of, because it's directly involved with patient care, but it's not directly involved with ocular care.
I think that it's reasonable to consider for COPE hours. I don't think it's reasonable to give them a full 8 hours. And I think just as a board, we'd have to decide, is this legal? Meaning policy-wise, can we add this?
Policy-wise, I mean, we sit there and approve hours based on their content and their profession as it is. And I mean, I get approvals for all that all the time. And it's probably within my purview to do that, but I think it needed to be a discussion among everybody.
And you've taken this course already, is that correct? And so has anyone else here taken the test yet? You're probably the most knowledgeable
I've
on what it
taken it,
contains.
and I would agree that it's not worth 8 hours. It does involve pharmaceuticals and things that we're licensed to prescribe, so I think it's reasonable to give some credit for it. The most I personally would feel comfortable giving somebody credit for would be 4 hours. But I'm wanting to get the flavor of the board and have some discussion. Oh, it took 8 hours. I think that it didn't have to, but you're going to spend 8+ hours at it, 8.25 hours actually. It's a video course of somebody sitting there talking to you, going over different issues and things. It pertains heavily towards addictions. And while we have, because of pharmaceuticals that we can prescribe and things, we have the ability to be affected by that, but we're not sitting there treating addictions on a day in, day out basis, and it's geared more towards that.
Was there a cost for the classes
There
or
was
just your exam fee?
It was not. So. And I'm not disagreeing with any of that. That's why I want this to be a discussion to where we come to consensus as to how we ought to. It's a one-time requirement. So it's not like we're going to have this every year after year. It's a one-time thing, at least at this point in time, to get your certificate, to renew your DEA. And we want everybody to, even though we don't require a DEA, we would just as soon everybody had it. So if you think that incentivizing people to continue to renew their DEA and spend their $800 or $900 to renew it as a benefit is that we give them full credit, I'm fine with that. But it's just, I think we need to come to a consensus.
I have 2 questions. So one, this would go towards the maximum of 8. 12, sorry. Oh,
Yeah,
okay.
and when they ask me, it's like, yeah, but you're limited to that 8 hours online. So if they take, at the time, that was the max that they could have online. And so if they took that and it counted, then
Right.
they were at their max.
Okay. Are there other instances where classes that are not directed towards optometry or ophthalmology are used for CE credit? Like, if I went to a family medicine class on pharmacology, could I submit that for credit?
You could make application for it.
Do people do that? Like, is that a thing we've done in the past, just out of curiosity? Do you know? I don't know if this is relevant. This is just, sorry.
I think that, I mean, mind you, I've been in this seat for a short time, but I think at some other meetings I've been in administrating Hart and some others, that we've made application for an hour here or there of that type of stuff that was approved.
Okay.
So I wouldn't think it would be, as long as it was relevant to something that could be prescribed or whatever. I mean, I think it's been approved before by this entity, nothing recently.
So I think I'd recommend that we make this an action item for the January meeting, which just means between now and then, maybe we have a proposed policy drafted. And then we can come to a consensus at the next meeting on how many hours, if we are going to accept it, how many hours. And I'm not sure, Jan, do we know how many optometrists in the state register for a DEA license?
No, I don't know if I can even run a report. I'll have to look.
Okay.
I can run a report.
Do you know, Todd?
Yeah, because
One
it's not,
thing I can tell you that has changed a few years ago, and this is about 3, maybe 4 years ago. DEA didn't used to be a requirement, but CanCare made it a requirement for their licensure about 3 to 4 years ago. So anyone that has a CanCare number or submits CanCare claims has to now have a DEA, where they didn't previously.
Okay.
So that's a large percentage of the doctors in the state that accept CanCare.
Any other questions you'd like Dr. Beaver to investigate for our next meeting?
Can you actually share the link or the website for this class? I haven't had to do it yet, so I don't.
Yeah, I'll go looking. I got it off the AOA's website.
Oh, okay, perfect.
Yeah.
Okay.
And I've got my certificate here on the screen, so I can pull it up off that too, because I thought I'd probably have to cut and paste it and send it somewhere. I didn't have to, and I have not submitted it for hours.
Something else to mention is it is not a test that's accepted by many entities to deliver. So the federal government is only accepting this version of the test at this time, meaning you would not be able to go to the KOA and get acceptable hours or go
Yeah.
to a meeting.
And there may be like 2 or 3 entities altogether that they accept, but this is the main blessed one.
Is that all from you today, Dr. Beaver?
Yes.
Okay. And then any report from a member at large? Yep. I'm looking.
I don't have any new business.
And any report from the public member?
I do not.
Thank you. I assume, Tim, your report's fairly lengthy.
Yeah, the only thing I'd say is I'd request at some point an executive session to talk about optometry statutes.
And then Ms. Belquist has returned. Can we see if Dr. Choate is available? I told him not to come back until 11, so it might be a little.
I'm here, if you can hear me.
Are you prepared, Ms. Belquist, to start? Okay. Let's go ahead and return to the reciprocity for Dr. Choate, which is case number 2025-07. And although an investigation was not opened, I have chosen to recuse myself from moving forward.
So I will now call to order the matter of John Choate, OD, case number 2025-07. Dr. Choate appears virtually and also through his legal counsel, Diane Belquist. We are here today to review and consider the application for a Kansas license by reciprocity submitted by Dr. Choate. Some preliminary matters. The board issued a notice of hearing regarding consideration of Dr. Choate's application on September 27, 2024. The notice indicated that respondent should submit any exhibits to Ms. Murray in advance of the hearing to be considered along with his application materials. The application materials consist of Dr. Choate's application for licensure by reciprocity, which is 8 pages and includes Dr. Choate's birth certificate as the 9th page, a license verification from the state of Arkansas dated April 1st, 2024. CE course history through OE Tracker from April 15th, 2022 to April 15th, 2024. The waiver agreement and FBI Privacy Act statement signed on April 8th, 2024. Dr. Choate's transcript from the University of Arkansas at Little Rock. Dr. Choate's transcript from Northeastern State University. Dr. Choate's graded law exam. The National Practitioner Data Bank query response for Dr. Choate dated May 22nd, 2024. Receipt relating to the application fee and fingerprint fee. 3 reference forms pertaining to Dr. Choate, including a March 27th, 2024 letter from a Thomas Campen, MD, who identifies himself as a medical director for Physicians I Group, and his NBEO official score report for Dr. Choate. Ms. Belquist, do you have any objection to the consideration of the application materials I have identified?
No objection.
Then I'm going to identify and admit the application materials as Exhibit 1 for the purpose of today's hearing. And Ms. Belquist, you have submitted proposed exhibits on behalf of Dr. Choate, which you have marked as Exhibits A through H. And they include Exhibit A, Accreditation Council on Optometric Education, Accredited Professional Optometric Degree Programs, dated August 12, 2024. Exhibit B, a September 30th, 2024 email, which purports to be from the Georgia Secretary of State Professional Licensing Division. Exhibit C, a letter of good standing from the Arkansas State Board of Optometry, dated October 10th, 2024. Exhibit D, sales receipt, which appears to be a duplicate of the sales receipt in the board's application materials. Exhibit E, an April 15th, 2024 email from Ms. Murray to Dr. Choate regarding his fingerprints and references. Exhibit F, April 2nd, 2024 email from Ms. Murray to Dr. Choate regarding the law exam. Exhibit G, entitled Sworn Statement of Dr. Choate. And Exhibit H, a copy of a June 30th, 2024 letter Tim sent to Dr. Choate. Are you wanting the exhibits A through H submitted to Ms. Murray, admitted into evidence today?
Madam Chair, in light of the proposed exhibits D and F being duplicates, I'm happy to withdraw them. If it's just simply more convenient to admit them, I certainly can move forward with requesting an admission. And then just clarification, Exhibit H was a letter from Dr. Bircher to my client, Dr. Choate.
Thank you. Yeah, then we can exclude exhibits D and
F was also the duplicate one.
Thank you.
Correct.
Okay. So outside of DNF, the other exhibits will be admitted into evidence. And then Ms. Belquist, you submitted a hearing brief on the equivalency of Arkansas licensure requirements to that of Kansas on October 11th, 2024.
That is correct.
Sorry, thank you. Okay, so you would like us to consider those?
Yes,
Okay.
please.
Is there anything else you wish to address, Ms. Belquist?
I would just propose to call my client, Dr. Choate, for examination, if that's the board's pleasure.
Yeah, we can do that.
Swearing in at all, or should we just go with it?
Mr. an oath here.
Sorry?
Yeah, and Mr. an oath for the witness. She's calling Dr. Choate. I can do it.
Okay.
Dr. Choate, will you raise your right hand, please? Do you affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Good morning, Dr. Choate. Can you hear me okay?
I can hear everyone that speaks directly into the microphone really well. Sometimes if you back away, it cuts out. So
I will do my best to
Thank you.
speak right into the microphone. Let me know if you cannot hear me, and I'll adjust as needed. Okay, so can you just go ahead and state your name?
John Carl Choate,
Where do you currently reside?
Sherwood, Arkansas.
And do you understand that we're here today on your application for reciprocal license in Kansas?
I do.
Do you remember about when you submitted your application to Kansas?
April, roughly March, April, I believe April of this year.
Tell the board where you received your education for optometry.
Northeastern State University in Tahlequah, Oklahoma.
Is it your understanding that that's an accredited institution?
It is.
Can you tell the board what other states you currently hold licenses in?
I have held a South Carolina license for a little over a year and a half maybe, and as of a week or two ago, obtained a Georgia license.
And so, do you have the exhibits that we were just discussing in front of you?
I do.
And is the Exhibit B reflective of that recent grant of your Georgia license?
It is.
When were you originally licensed in Arkansas?
July of 2019.
Did you take and pass an examination for that original licensure?
We did. We had an in-person examination.
And in the last 24 months, or really ever, have you been subject to any investigation or proceedings in Arkansas that could potentially result in disciplinary action against your Arkansas optometry license?
I have not.
Did you request a letter to that effect from the Arkansas Licensing Board?
I did.
And is that reflective of Exhibit C?
That it is.
From your perspective, do you believe that the licensure requirements in Arkansas are equivalent to the licensure standards in Kansas?
I do, yes.
Okay. With respect to South Carolina and Georgia as of last week, have you ever been subject to any investigation in those two states that could potentially result in disciplinary action against either one of those state licenses?
I have not.
Okay. How long have you been actively practicing optometry?
A little over 5 years.
And where are you currently employed?
I am employed by Arkansas Physicians Eye Care Group in Little Rock, Arkansas is where our clinic is.
What's your position there?
Optometrist.
Are you an owner or manager at all?
I am not.
How long have you been employed there?
Since July of 2019.
And can you just kind of describe your practice for the board?
Sure. I am the only in-person optometrist on in the clinic. I'm there seeing patients 9 to 5, 5 days a week, performing comprehensive eye exams.
And has that been the case for the entire about 5 years that you've been employed there?
Yes.
Okay. Have you reviewed the Kansas optometry laws?
I have.
And have you prepared a sworn statement that you have not failed the Kansas examination for licensure within the 5 years that preceded your application date?
I did.
Is that reflective in Exhibit G that's been provided to the board?
Yes.
Okay. Can you talk to the board about the malpractice insurance requirements if you're granted the privilege of practicing in Kansas?
I am covered in any location that I practice by my current malpractice policy.
Okay. Do you believe you're of good moral character?
I do.
What, in your mind, demonstrates good moral character?
Looking out for the patient's best interests at all times, being an upstanding citizen and certainly not being investigated or having any negative legal history.
You don't have any criminal history, correct?
Correct.
And you don't have any licensure disciplinary history, correct?
Correct.
Why are you applying for a license in Kansas?
I am applying to perform refractions remotely as delegated to me by a medical doctor who will otherwise conduct the examinations and issue prescriptions.
Who's your prospective employer in Kansas?
Dr. Michael Parsons of Kansas Physicians Eye Care Group.
And Dr. Michael Parsons is a licensed ophthalmologist?
Correct.
Do you intend to relocate to Kansas?
I do not.
Do you believe that that proposed practice complies with the Kansas optometry laws based on what you've read and studied?
I do.
Okay. Is there anything else that you would like the board to know in consideration of your application materials?
No.
Okay. Now hold on, because the board members may have additional questions for you, but that concludes my direct examination.
Do any of the board members have any questions for Dr. Choate at this time?
So it's my understanding that you said you have face-to-face practice in Arkansas?
That is correct.
And so you do your refractions in Arkansas in person?
I do.
Why do you not do those virtual in Arkansas?
I am there in person, so I choose to do them in person.
And do you feel that that is equivalent patient care, whether you're in person or virtual in Arkansas?
The refractive piece you're asking?
Yes.
Yes, and for virtual, I would only be performing refractions as delegated by the medical doctor who will be, issuing prescriptions.
And that medical doctor will be seeing patients in person?
I am, that would not be my role in that relationship.
So you don't know?
I would not be responsible for the rest of the examination. That would be under the medical doctor.
So you would strictly be a refractionist if that term is actually in existence?
Sure, yes.
And if a patient has a problem seeing out of their refraction, how is that dealt with?
That would be under the, responsibility of the ophthalmologist, Dr. Parsons, to conduct the rest of that examination.
So if they had a problem after the fact, they would be following up with him, not you?
That is correct. He would be responsible for the patient's overall care, and I would be working under his supervision.
At this time, are there any other questions or any motions?
If I can clarify, Dr. Cho, this is Tim Racer, counsel to the board. So the relationship you anticipate, Dr. Parsons would be the one who issues. I understand the health or medical aspect would be
Sure.
Dr. Parsons, but Dr. Parsons would also be issuing the ultimate prescription to the patient. Is that the intention?
Correct. The glasses and/or contacts prescription would be issued by him, not me.
Thank you.
What would you be using your license to do?
To work under Dr. Parsons, and then certainly if I had a license, could consider seeing in-person patients, but that's not. I don't have any official plans at this time to do that.
But you intend to use the license how?
Currently, I only intend to be, operating in a manner that is not causing any friction in our mode of practice, just to work under Dr. Parsons and assist in his patient care
By doing what?
by performing remote refractions.
Am I able at this time to make a motion for,
I'm sorry, I can't.
sorry, my
Sorry.
words are
Thank
not
you.
coming to me right now.
Okay.
I kind of trailed off. That was me, not you.
Sorry.
Can I make a motion to meet in closed session?
Yeah, that motion would be in order if, does any board member have additional questions for Dr. Choate or Ms. Belquist? If you want to recess to closed session to deliberate, you certainly can, but make sure we ask all our questions before we go. Yeah.
I think,
Be our final opportunity to ask questions.
No, you'd have the opportunity if you want to ask additional questions after a closed session if the board has them, but
I do have an additional question while we're in this mode. So you're wanting to be, and I'm going to still use the term refractionist. Why do you need a Kansas license if you're saying you're an assistant under the direction of Dr. Parsons?
I'm just going to object lightly to say that if he has a response, that's fine. He can go ahead and respond. But this witness isn't necessarily knowledgeable on all aspects of Dr. Parsons' practice and authority to delegate, supervise, to the extent that that question reaches anything beyond his personal knowledge.
Okay, so can you clarify it for me if it's within your personal knowledge?
Well, just because a license may not be needed doesn't mean that a doctor wouldn't want the extra assurances of somebody being licensed and having the additional malpractice insurance that could potentially come in play in different scenarios. There's reputational, legal, operational considerations that someone would opt to have a higher credentialing licensed person in their practice rather than.
But would he not be presenting himself as a doctor to that patient while he's doing the refraction?
If he's licensed in Kansas, he certainly would have the authority to do so.
But yet he's not administering the examination in his own words there a second ago.
It'd be limited scope of how he implements his optometry practice in this setting.
But we don't have a limited scope law.
We don't have a law that requires him to do anything with a license. He could certainly have a license and then not actively practice. So there isn't a requirement under the law that he, with his license, do anything. There is a requirement that if he chooses to use his license, he must comply with the optometry laws. And that's what he would be doing under this.
Which would be providing appropriate patient care under the law.
Yeah, and I believe that you've heard from him as far as the scope of what that patient care would be. I'm sure he'd be happy to answer any other questions if you had concerns about the standard of care.
so back to Dr. Beaver's question. There was an objection regarding the knowledge or limitation with respect to how Dr. Cho could answer that.
Yeah.
Do you still have your question
I still
pending?
have my question pending. I do.
Dr. Cho, do you understand the question? Or would you like Dr. Beaver to rephrase?
Maybe rephrase, please.
Well, again, you're saying that you're being a refractionist under Dr. Parsons. So I guess I have some concerns as to when the level of care from one doctor to the other passes and the patient, one, being aware of their level of care that they are or are not receiving. And if you're telling me that you're not of the knowledge of what level of care he's going to be providing, but yet you're also seeing that patient, if it's confusing to me, it's going to be even more confusing to a patient as to who, where, when, and why, and how did they receive care, and how do they follow up if they've got problem with that care.
Absolutely. And ultimately, all of the patients that I have current plans to see would be under Dr. Parsons' care. So I would not be presenting myself as a doctor without a license. I would not be responsible for patient care.
Well, with or
Even,
without a license,
even
you're
with the
saying,
license,
you're saying
correct. It
that
would be
follow-up care would be with Dr. Parsons.
Dr. Parsons,
So my
absolutely.
question is Dr. Parsons actually seeing that patient?
Be a great, question for Dr. Parsons, who's ultimately responsible for that. My role, my current role that I am interested in employing and working with patients would be limited to the refractions under Dr. Parsons. I don't have any other hard plans at the moment, to conduct the examinations fully myself with my name on that.
But if we grant you a Kansas license, we're granting that you're going to be able to care for that patient if necessary.
Along those lines, Dr. Choate, do you intend to practice optometry in the state of Kansas?
I have no current hard plans to do that.
You have no intention to practice optometry in the state of Kansas?
Today, I do not have any intention, anything in the works to move to Kansas and practice optometry.
Do you have any intention to practice optometry in the state of Kansas regardless of where you reside?
Not outside of the way that we have laid out in the last few minutes.
So you don't intend to practice optometry in the state of Kansas?
I would object to that. I think that that calls for a legal conclusion that's outside of this witness's knowledge. He's already testified that he believes that, he's testified that he is going to practice in the way set out.
Madam Chair, would you like to sustain or overrule the objection?
Her objection?
Mm-hmm. Or would you like a sidebar to discuss?
I would love to sidebar.
Okay. Why don't we step out of the room very quickly?
Okay, thank you. Okay, as to that objection, I will sustain in part that it does call for some aspect of legal conclusion and that the facts of what he will be doing have been testified to. At this time, does anyone have any questions along another line? Or I would entertain a motion for closed session if there are no other additional questions.
I'd make a motion that we meet in closed session.
I'd second that for at least 30 minutes.
Yes.
Okay. All in favor?
Aye.
Aye.
All right, so we will close session for 30 minutes and reconvene at 11:46. calling the meeting back to order at 11:47. And I would accept a motion for an additional,
I make a motion that we go back into executive session for an additional 20 minutes.
I'll second.
all in favor?
Aye.
All right, we will be back in closed session and reconvene in 20 minutes at 12. It is 12:08. Calling the meeting back in session. Is Dr. Choate still with us?
I am here.
Okay, thank you for waiting. I believe we have some members who have a few additional questions for you, Dr. Choate.
So Doctor, I do have a question for you. And based on everything I've seen, you've taken and passed the Kansas law,
That is correct.
which section KAR 65-8-1, examination and adaptation procedures. The following minimum standards for examination procedures shall be performed by a licensee during any examination conducted to determine a prescription for contact lenses should be provided. And we go down through a series of things that are minimum for any refraction to be done. But from what you told me earlier, it's not your intention to do any of the, only the refraction. Is that correct?
I would be assisting Dr. Parsons in getting that refraction completed. Yes, but ultimately he would be responsible for any contact prescriptions and glasses prescription.
But there are other tests, including ophthalmoscopy, biomicroscopy, tonometry, coordination testing, refractions, that are all requirements within our statute if you're performing any type of refraction. How do you intend to do that? I'm reading a copy of the law.
I can't hear Ms. Belquist, sorry.
And I think the objection was, you said they're part of the refraction as opposed to.
Pardon me, for the determining of a prescription. Okay. So the parts you talking about.
Sorry, I'm still unable to hear Ms. Belquist. I'm sorry.
Dr. Choate, I had just objected and that's been resolved, so now the question is going to be posed to you.
Okay, sorry, I thought I saw you speaking.
So my question is, if you're determining, pardon me, let me reread this from the beginning. The following minimum standards for examination procedures shall be performed by a licensee during any examination conducted to determine if a prescription for corrective lenses should be provided. Now, I can read off, there's visual acuity testing for each eye far and near, external examination, refraction, objective and subjective, coordination testing, ophthalmoscopy, biomicroscopy, and tonometry are the 7 items on the initial section. I'm not going through the pages following. How do you intend, with what you're saying that you're going to be doing, to know or to provide services that make you compliant with our statute of care?
Objection to the extent that that question suggests that he must comply with those requirements. As we've heard today, he has indicated that he is not going to be determining the prescription for corrective lenses. And so my objection is to the phrasing.
I didn't say determining the final prescription. As you mentioned, reading the law, if a prescription for corrective lenses should be provided. So he's not, that doesn't say providing the final. It's just a matter of determining if one should be, which is what he's talking about doing.
So, and I think the factual aspect of that question was how would he provide or how would he know that each of those examination procedures are performed? Is that a fair characterization?
Yes, that's fair.
Question.
To the extent that he is talking about his own, because again, we have the medical physician that's involved in the equation, and this regulation does not govern the medical physician's practice and involvement in this equation. So when he's not doing an examination for his own determination of a corrective lens, the argument is that we don't even get to 65.8.1. It's not applicable to the situation.
No,
We have a medical physician.
I understand. I just think as, the question as he phrased it was, how are you going to provide, which, he can testify to, or how would you know that they're being provided, which he could either testify to or he wouldn't have knowledge. Do you object to him answering that question?
How he knows, to the extent that he has any anticipated plans of how that would be carried out, I just want to be mindful that he doesn't have a license. He hasn't been employed yet, and so there aren't the operations that are in place in the workflow process yet. But to the extent that he has knowledge as far as how it would be intended to be carried out in practice, certainly that's fair.
Okay, and Dr. Beaver, if I may. So Dr. Choate, the question that's been posed to you with respect to the procedures listed there in KAR 65-8-1A 1 through 7, how do you intend to provide or know that those procedures will be performed?
My role currently would not be to be responsible for those aspects of the exam. It would be directly to assist Dr. Parsons in his, making of that final decision. I would be operating strictly under his supervision.
And will Dr. Parsons be present?
I have not been employed as of yet. I'm just seeking licensure. That'd be something that would be discussed once, we move forward, which we have not yet.
So you maintain that you do not know if Dr. Parsons will be present at this location?
I have not lined out any of the employment arrangements at all.
So you are aware, though, that if you are a licensed practitioner in Kansas, so if we grant you this license, then you do follow under these guidelines of tests that you will have to perform at a minimum to be compliant with our state law.
I object to incomplete factual set for the conclusion that's being drawn.
We have minimum standards for evaluation. He has taken the law, he has passed it. My question is he aware of the content of the law for testing that he would be responsible for?
Same objection.
Same objection.
Okay. Madam Chair?
Word it for me one more time, Dr. Beaver.
Having taken the law and passed it, if we were to grant him licensure, does he have any question of our minimum examination requirements that he would be responsible for if he was performing an evaluation on a patient?
And the objection is?
So the question, if it is concluding that KAR 65-8-1 subparagraph A would be required to be performed under the factual scenario that Dr. Choate has been describing what his intended practice would look like in Kansas remotely, that is an incorrect conclusion of law being stated in there.
Okay, so then let me, Madam Attorney, let me ask you this. If he is an unlicensed person, he is under your doctor that's under the healing arts. But if he's a licensed person, he's no longer under your doctor's guidelines of healing arts. He's under this optometry board.
So if I can use that as a segue to follow up, there was a question asked earlier about can he do what is being proposed without an optometry license in Kansas? And I do want to add to what I had previously stated. Under the Kansas Healing Arts Act, which governs medical physicians, obviously not within this board's regulatory authority, but it is in the Healing Arts Act governing ophthalmologists, they are prohibited from delegating to an unlicensed individual the examination of the eye or acuity in those acts that are governed by optometrists. So there is the other line of regulation that we have interplay here. So under the proposal of what he would be doing, the license is required if we're looking at the Healing Arts Act as it governs the medical physician. With respect to, I forgot, I'm sorry, can you repeat the question?
Well, so if the license is required, it's required because there are minimum standards that have to be met. And my question is how he's going to meet those minimum standards.
Correct. So it is not an either or of a regulatory authority here in this practice scenario that's being proposed. There is going to be dual regulatory authority in which Healing Arts is going to govern, obviously, the physician. The optometry board, if you grant the license to Dr. Choate, he is absolutely going to be governed by the optometry board, subject to the regulatory jurisdiction. And it's not an either or of where a physician can delegate to somebody that is unlicensed but not an optometrist. There can be, as we're proposing, and as Dr. Choate has been doing in other states even, the medical physician can delegate and supervise functions to a licensed optometrist, and that just because the licensed optometrist would have the independent authority to do a full examination and comprehensive health evaluation doesn't mean that there can't be the supervision and delegation as structured.
What's done in other states is really irrelevant to Kansas. It's Kansas statute that governs what he has to do or is responsible for or liable for.
Certainly, and we
I mean, that would be just like saying, well, you know, since he's under that doctor, he doesn't have to have malpractice insurance. I mean, it's there for a reason. And my question, which he has not yet answered, is how are you going to know because of patient care that this is occurring?
I just want to make very clear that in the proposed structure, there is this regulation, 65-8-1, we are making the argument that does not apply. He does not need to meet all of these requirements. And that's because of the unique structuring of this practice.
But we haven't seen a structuring of the practice that you're talking about.
To the extent that he has testified about the intent of the delegation and supervision.
The intent of the delegation, and what he told me earlier with questions was, I don't know.
Would you care to speak to the structure of?
Well, here's the trouble, right? And we need the license first, and then he is employed, and then the practice operations carry out in the nuanced, sense of it, of what you're asking. We have the large concept here in which he is eligible for reciprocal license. So that's step one. And once he is granted a license, then he is going to be obviously subject to this board's jurisdiction and regulatory authority, and he is intends to have the scope of practice be that which is delegated by the medical physician. And that is not, in this scenario, is not to issue the prescriptions. So we definitely know that, and that has been testified to, with certainty here. With respect to what is an employment contract going to look like? I don't know. He doesn't know. That hasn't been, finalized yet. With respect to day in operations of how is he going to interface with Dr. Parsons, he hasn't had that opportunity yet to solidify that relationship and figure out what does that look like in the operational effect.
So we're still dealing with minimum requirements to help watch out for the patient and the public and care. And for you to just say that these minimum requirements don't apply doesn't really address the intent of the law. I mean, you're saying these don't apply. Well, that testing does apply for a patient. Nothing says final prescription, written prescription. It's the to determine if a prescription for corrective lenses should be provided. It doesn't say it's provided. It's just the evaluation of if. And these minimum requirements still have to be met, which he would be liable for if he's a licensed entity.
I respectfully disagree. I definitely appreciate that it is a statutory interpretation issue. I think the law can be interpreted that when a licensee performs the examination, then that licensee, being defined as an optometrist under this act, then if it's an examination for the corrective actions, then they must do X, Y, Z. So I respectfully disagree. I think I've made the argument that KAR 65-8-1 does not apply to the practice as he's described it. But with respect to patient care, that is obviously the utmost concern for any optometrist, and he certainly is going to be ensuring that his professional services are going to be meeting the minimum standards, exceeding the minimum standards. So,
At this time, does anyone else have any other questions for Dr. Choate?
Dr. Choate, do you believe the business arrangement with Kansas Physicians Eye Group that's been proposed here, do you believe that to be in the best interest of patients and the public of the state of Kansas?
I do.
Do you have any question as to Dr. Parsons' participation on his end of the eye exam, since you'll be participating in concert with him? Do you have any concerns or questions about the rest of the eye exam as it pertains to public health?
I do not at this time.
You have no concern?
I have no concerns at this time.
Thank you.
Thanks.
Dr. Choate, would you mind expounding on, so Dr. Parsons asked you, or I'm sorry, Dr. Walters asked you if you believe the arrangement is the best interest of citizens of the state of Kansas. Would you mind expounding on your yes answer?
Maybe a better answer would be that I have no reason for concern that it would be, against public interest. So apologies. Maybe that would be a better way to say that.
Just off the cuff here, have you ever come into, because you perform in-person eye exams at your current location, correct?
Absolutely, yes.
Have you ever walked into an eye exam with one idea of what might be going on with the patient and left with another idea?
Of course.
Are you concerned that there is no in-person interaction happening as far as your participation is concerned?
I've, done remote refractions for probably a year and a half in different states, and I've found it to be, I found it to work very well. And patients that had other concerns certainly have access to the ophthalmologist or, in my case, the optometrist to discuss concerns, abnormal findings, thinking something was going one way, goes another, and then having a good network of local referral centers to ophthalmology, different specialists. It's really worked really well in my experience.
In those other settings, are there optometrists or ophthalmologists present with the patient?
Not every patient every day, but we have access to local care when needed.
So there's no licensed practitioner present with the patient when you perform remote refractions?
In certain scenarios, I would be the licensed person, not necessarily in the same room. And then there are on-site doctors at different stores, but it's a little unique in every scenario.
Any further questions?
Madam Chair, may I ask Dr. Choate one final question, very briefly?
Please do.
Okay, Dr. Choate, would it be a fair analogy to liken what a nurse does, with the nurse being independently licensed in support of a physician's family practice, and then take that scenario and kind of liken it to what you would be doing here with respect to aiding and assisting Dr. Parsons with his medical practice?
I believe so. I'm sure you could find some inconsistencies, but I believe in general, whether it's an APRN, a PA working under the supervision of an MD, I'm fine with that.
Okay, thank you.
One last question. Dr. Parsons that you'll be working with, where does he reside?
I have not pursued that relationship without the Kansas license, so I'm very limited currently on my interactions with Dr. Parsons. That would be something that if, I was able to be in good standing with the board, being well aware of the mode of practice, then that would be a relationship I would further once it was necessary to go down that path. But
Do you work with Dr. Parsons in other states?
I have not, no.
You have not?
Different ophthalmologist under the same mode of practice, but not directly with Dr. Parsons.
So within the same group as Dr. Parsons then?
I don't know necessarily the particulars of that. I wouldn't know their relationship to each other necessarily.
Okay, so he's not part of the same group as other ophthalmologists that you work with?
I really wouldn't know their relationship to each other.
Any last questions, board members? Any additional comments, Ms. Belquist?
Yeah, thank you, Madam Chair.
At this time, may I make a motion? Or do I have to ask for a motion?
Yeah, best to ask for one.
I would entertain a motion for action on this application for reciprocity.
I might ask that we convene another closed session.
Is that a motion?
I would move that we convene another closed session to discuss some of the new information that's come to light.
Second, or do I have a second? Sorry.
Second.
All in favor?
Aye.
Now, we're not required to give a time frame, but maybe we should give everyone a time frame of when we're coming back.
10 minutes?
Okay.
All right. All right, calling the meeting back in session, 12:39. Do I have a motion?
I'll motion that we, based purely on the legal statutes, accept the reciprocity case for Dr. John Choate.
I'll second.
Is he on here still?
Dr. Choate, are you on?
I am, yes.
All in favor?
We have some discussion.
Oh, yes. Would you like some discussion?
So I have a real problem with, I mean, while you may be eligible to be licensed in the state, I have a real problem as with how the care of the patient is going to be taken care of. And my concern is whether you feel like you have any obligation for that or not. And I have no problem if you become licensed for us pursuing whether or not our standard of care is being met in the state. And once you're a licensed individual, you would be fully liable for that standard of care. And I think that so far, the appearance is that legally you're trying to circumvent that, and I'm worried about Kansas patients suffering from that. So that's my statement.
I share Dr. Beaver's concerns as well. I think that the basis of our discussion today is are the licensing requirements met for Dr. Choate? And so I think that's what we're voting on.
Yeah, Dr. Choate, I hope you'll pay a lot of attention to the particular regulation brought up by Dr. Beaver and also to the one on professional judgment as you figure out what your exact arrangement will be in Kansas to ensure that our patients are getting the quality of care that they deserve.
I also think it's reasonable, given the history with the practice of optometry and ophthalmology at this location, that you should be aware that this location may be under scrutiny by this board to ensure that proper care is being taken. Because our main responsibility, our main charge is to the people of the state of Kansas to make sure that they are receiving the utmost level of care. And I don't think that you've convinced this board that you intend to provide a level of care that's commensurate with the statutes of optometry. However, meet the licensing requirements, and we've been advised legally that that's what we're voting on.
Any further discussion? All in favor?
Aye.
Aye. All opposed?
Aye.
Motion for application to accept, to accept application for reciprocity for Dr. Choate is passed. Thank you.
Thank you for your time.
I just want to check in with Todd. I'd like to move along with light adjustable lenses, but I know you have a call at 1. So do you have anything you'd like to present before we rattle along? Well, either that or just your public comments.
So thank you. Todd Flusher with the KOA. A couple of things. Appreciate the clarification about the course, or that there's going to be some clarification about the DEA course. I've been telling people that it doesn't count just because it's not COPE or approved by the state. So I said, once you get that, I'll appreciate that so we can share that information to our folks. As far as the light adjustable lenses, I'll just make a quick comment on that. You know, that is one of those things that we believe is within the scope of practice of an optometrist, but we also respect the board's ability or the concern that they have to make sure that they have the authority to share that and, you know, make that judgment call. So we are happy to support you on whatever efforts you have on that, and otherwise we'll just wait for your response on that. So thank you. Any other questions for me? Okay, thank you.
We have a lot of information to discuss about light adjustable lenses. I thought I'd do a small introduction to kind of bring you up to snuff on what this is referring to. So a light adjustable lens refers to an implant that is inserted into the eye with standard cataract surgery. So the surgery is the same surgery that's been happening for decades, but the implant itself is a new technology. This is a silicone intraocular lens that is placed into the eye, and then after the surgery, you can manipulate the power of the lens. So ideally, patients have 20/20 vision guaranteed, which cataract surgery cannot do if you've had LASIK or RK or any other eye issues long term. And so this lens is altered with UV light, which is administered from an instrument. And the procedure, I don't know if I can call it a procedure, is a common, how do I say this? The way the procedure is delivered is a common technique that all optometrists are trained and use daily in clinic. What is not trained is just the foot hitting the pedal and turning the light on. So we're not really questioning the procedure itself as much as what is optometry's role with a light adjustable lens. So some of the questions we'll be discussing today, is light adjustable lens within the scope of optometry? 2, does the board have the legal right to make that decision if light adjustable lens is within our scope? And then also, I think we will discuss a few of the other states that we have lawsuits coming out and so on and so forth. So I believe we maybe have some comments, aside from Todd, from the public about LAL or?
The Society of Eye Physicians and Surgeons. We just recently became aware that this issue was going to be on your agenda. Not real prepared to get into the whole discussion of whether it's within the scope of practice. My board, the Eye Physicians and Surgeons, are currently discussing that amongst themselves. We haven't determined what our thoughts are on it. We're also meeting with the Kansas Board of Optometry, trying to set up a meeting to determine whether we can come to an agreement with them on whether we need statutory language or whether it is within the scope currently. So we would just respectfully request that you delay this until after we have some discussions and can decide between ourselves what we feel is appropriate.
Thank you.
Sorry, did you, a meeting with us? Kansas Board of Optometry?
Sorry.
Oh, Kansas Optometric Association, okay.
I would like to make a motion to go into executive session to have privileged client-attorney conversation with Tim Resner regarding some of the statute information with light adjustable lenses. I am going to request 30 minutes, so it is 1:48, and coming back into session at 1:17.
I'd second that.
12:48. 12:48.
I'd second that.
Any discussion? All in favor say aye.
Aye.
Aye. All opposed, same sign. All right, we will head next door for All right, it is 1:17, and I'm going to open the meeting again. I think from our discussions, we have 2 action items we'd like to present. And the first is that the law is very unclear on what the appropriate scope is. And so for now, we will rescind the statement in the newsletter and just announce that we are considering further options moving forward. Jan will be sending out a notification to licensees.
Is there a motion to that effect, Dr. Burke?
Would anyone like to make a motion?
I would make the motion as you just worded it.
Do I have a second?
I'll second.
Any discussion? All in favor say aye.
Aye.
Aye. All opposed, same sign. And so that motion passes. And so Jan, maybe we'll have Tim review that notification before it goes out. The other action item that we will present is because the scope is so unclear, I would like to make a motion to contact the Attorney General's office to have them aid in the decision-making on whether or not this comes under the scope of the optometry law. So if I make a motion to send the LAL information to the AG's office, do I have a second?
Second.
Any discussion? All in favor say aye.
Aye.
Aye. All opposed, same sign. All right. I think Tim will probably keep us updated on how that process is going. And I think he'll be contacting all parties to allow them to give their input on the situation with the AG as well, so. Okay.
Yeah.
Any other concerns with the LAL information? Okey-doke. All right, I am going to default to Tim for the report of the legal counsel.
Yeah, so I'm requesting an executive session to go talk about more optometry statutes. Communications would be attorney-client privileged. And I would hope we could do it in 15, maybe 20 minutes.
All right, do I have a second?
Second.
Somebody needs to make the motion.
I move to go to closed session for client privilege discussions.
Yeah,
10 minutes.
with the subject matter being discussion of optometry statutes.
Subject matter of discussion of optometry statutes.
And then do I have a second?
Second.
Any discussion? All in favor say aye. Aye. Opposed, same sign. And so it is currently 1:18, and so I will give us 20 minutes in closed session. is 1:45, and we're coming back into session. Anything else to conclude, Tim, with the report of legal counsel?
Nothing more from me.
I would recommend a delay on regulation update. Does anyone have any concerns with that? All right. And then, Jan, do you want to discuss our next meeting date?
Okay, so the next meeting you guys have scheduled is January 8th. I don't have a time, I don't have a place yet, but it's also enough time out there that we can actually have the hearing for the two regs that just got through the AG's office, 65-5-2, which I think is application for the exam, and the other one, 65-8-4, which is contents of a prescription. So I can schedule that for that day. What time would you guys want to start? I'm assuming we can get these two rooms again.
How about you guys that drive further? Would you prefer a 9 o'clock start time?
What time? 9 o'clock?
Let's plan on 9 o'clock.
Okay. Yep.
And then for ages, we have been talking about having a board training session. And Jan would really like to get this done before that next meeting. Would you agree?
It would be nice, yes.
So can we discuss everyone's availability for board training? We would have OTIS speak. We would have several of our investigators speak. We would have former board members speak. And I'm sure Tim has information to relay to us, possibly Jan as well. And I think what we just need to determine, is this a Saturday thing? Can people, are you willing to close clinic a day? So I'm putting that out there. Yep.
That's all we would do. That would be the only thing on the agenda, would be board member training. I wouldn't put anything else on there, so we would get it done.
Jan promises not to put any reciprocities on that day.
The only way I would is if they're in that expedited licensure crap.
It would be an open meeting, so.
Yeah, it has to be an
To the
open
public.
meeting too, so.
It's a horrible time of year. I'll just say that out loud.
No, we're talking
We're talking about before January.
November, December.
Mm-hmm.
Yeah.
Well, that was our intention in July. I would have said not recommended by council. Would you agree?
Tell me one more time.
To schedule our board meetings around association meetings.
Yeah, I mean, ultimately your discretion. I think you all moved away from that a little while ago.
We used to, at least the spring KOA. It was,
There's just a lot of,
or the morning of.
I guess Dr. Hansen made a decision to separate the meetings for a reason, and it's recommended by ARBO. There's a lot of good reasons to say separate, which we can get into later. But.
Yeah, that's more or less it.
100% Dale Atkinson is like, you should never have meetings in the same building, same weekend, anywhere near.
Yeah, see, there's that.
During the same time or in the same building.
Yeah, but it's the same time.
Well, the old KOA meeting was, or the old board meeting was during the KOA.
It was like
During the meeting.
yeah, it was like, yeah, it was like, in April, it was like Friday morning in April, when everybody was out playing golf, is when they would
Gotcha.
have the meeting.
Something we can put on the table. I just know there's a very specific reason that Dr. Hansen made
It was
this
just,
decision. And I forgot why we want it before January.
It's just to, and we can maybe do it January. If I keep January's light, maybe we could do it in the afternoon of January 8th. We start at 9.
That would be preferable, but were you more worried about the security issues from OTIS?
Yeah, because they would do, what they proposed to do was to do a simulation of something that happened directly to our board. Somebody hacked into our database and stole all the licensees' PII. And what do we do? How do we handle it? Yep. It's OITS security. How?
It's security training.
Security training,
Which is interesting since our database won't work until 2026.
well, the current one. Yeah, no, the current one.
Gotcha.
Because everything.
I would agree. I would really,
I mean,
I think that's
full day, okay, I'll bring.
no executive sessions.
I'll second that motion.
And then because of that, would you want to bump the meeting up to 8? And then do we just have as much time as we can to squeeze as much in?
Yeah.
Okay. Yeah. I'm in wrestling season, so.
8 o'clock.
And then, so Jan, do you feel comfortable contacting, I know we don't have a set agenda yet, but contacting the list that we made and kind of getting a good feel for former presidents, investigators, OTIS?
HR.
Maybe Judge Snell will do a Robert's Rules. Rule of Roberts, whatever it is. All right.
That way they can at least get it on their radar and make arrangements if they need to take the day off. And I'm assuming if they needed to come in the night before, the board would pay for it. The ones that have to drive.
Anything else to address for today's meeting? It was a whopper. Is it? Bump on a log. And would anyone like to make a motion?
Second.
Any discussion? That's new for me. I've never asked that before. All in favor say aye. Aye. Aye.